Has something gone wrong in the drafting? Where a clause in an insurance policy makes little sense or seemingly cannot express the intention of the parties, how far will the courts go to enforce what they perceive to be the intent of the agreement? This question comes to the heart of the English approach to interpretation of contract. Contract clauses will generally be given their express ordinary meaning, the parties, within certain limit, having the freedom to contract on whatever basis they wish. The court will only reluctantly intervene and, where it does, must be very clear and careful about the ground. The recent judgment in Blackburn Rovers Athletic Football Club Avon Insurance considered these issues afresh. In this case, the Blackburn Rovers striker Martin Dahlin suffered an injury to his back whilst taking part in a training match. Although it was not immediately clear that the injury would have long-term consequences, it proved to be serious enough to prevent him from competing in top-class football, and ultimately his disability put an end to his professional career. Blackburn had obtained insurance from the defendant against the risk of injury to its players and made a claim under that policy. The insurers rejected the claim on the ground that Darlin's disablement had not been caused by the injury alone, but resulted directly or indirectly from a degenerative condition of the lower spine and was therefore not covered by the policy. The insurance policy paid out in the event that an insured person sustained an actual bodily injury or illness. 100% of the sum insured was payable in the event of permanent total disablement. Under the exclusion section of the policy, however, it states this insurance doesn't cover death or disablement directly or indirectly resulting from or consequences upon permanent total disablement attributable either directly or indirectly to arthritic or other degenerative condition in joint, bones, muscle, tendon, or ligament. The judge expressed the issues relating to the application of this exclusion were to be decided as follows: whether the exclusion was incapable of bearing any rational meaning, whether it was to be literally construed in favor of the issuer, and whether degenerative change that were typical of the male population of the relevant age and typical of top-class professional footballers of Dahlin age were to be disregarded when construing the policy. The exclusion certainly appeared difficult to apply. As drafted, it applied only to disablement which itself resulted from permanent disablement. There could thus be very few circumstances in which this exclusion could operate. The judge was consequently faced with a difficulty. Should he interpret the clause literally with an effect that in his view cannot have been intended by the parties, or did he have the scope to take a broader approach to the interpretation of the clause? The judge was assisted by previous authority. For example, in Yorkshire Water Services Limited, Sun Alliance and London Insurance, Lloyd Rep 221, it was held that a literal construction that leads to an absurd result or one otherwise manifestly contrary to the intention of the party should be rejected. Even alternative, more reasonable construction can be adopted without doing violence to the language used. This recognition of the need to give a policy sensible meaning consistent with its fundamental purpose has led the court on various occasions to overlook obvious grammatical errors and, where necessary, even to disregard inappropriate phrases as surplusage. Basing his opinion on this, the judge said he would not hold either that the clause simply had no rational or an extremely limited meaning. Instead, he held that the intention of the parties could be understood from the words they used in the particular clause, even if that necessitated treating some of those words as surplusage. It was possible, he said, to ignore the word permanent total disablement attributable either directly or indirectly to, as this duplicated earlier language in the exclusion section of the policy. The judge then decided that this was not a case of ambiguity or unclear meaning to be resolved in favor of Blackburn. Instead, it was an example of something having gone wrong in the drafting, despite clear intention. Thank you.